So earlier, I went on a tirade about the fact that a lot of the rights that marginalized communities have is because of Black people, specifically rights that were deemed constitutional under the 14th Amendment. The 14th Amendment, which was created to give Black people citizenship. The first clause is the citizenship clause, and to give Black people equal rights. And oh, look, everybody else has been able to obtain equal rights for a variety of things under the 14th Amendment. Look at that! Why am I bringing up the 14th Amendment? Because we are going to be looking at some court cases that provided basic civil rights to the LGBTQIA plus community. They were deemed constitutional under the 14th Amendment. And we will be starting with Lawrence versus Texas. Now, Lawrence versus Texas, which was in 2003, is a landmark case in which the Supreme Court of the United States, in a 6-3 decision, invalidated anti-homosexual physical activity laws across the United States, making same-sex economy activity legal in every state and the United States territory. Some background. Legal punishments for homosexual economy activity often included heavy fines, prison sentences, or both with some states, beginning with Illinois in 1827, denying other rights such as suffrage to anyone convicted of the crime of homosexual physical activity. As of 1960, every state had an anti-economy law. In 1961, the American Law Institute Model Penal Code advocated the repeal of these laws as they applied to private adult consensual behavior. Fast forward to 1986, Bowers versus Hardick. Now, we'll talk more about this in detail, but at a high level, the Supreme Court heard a constitutional challenge to anti-economy activity laws brought by a man who had been arrested but was not prosecuted for engaging in oral lovin' with another man in his own home. The court rejected this challenge and emphasized that a separate court case, Einstadt and Roe, had only recognized a right to engage in procreative sexual activity, and that long-standing moral aversion toward economy was enough to argue against the notion of its right. Now, I want to note that by the time of the Lawrence decision, which was 2003, 10 states, Alabama, Florida, Idaho, Louisiana, Mississippi, North Carolina, South Carolina, Michigan, Utah, and Virginia, still banned consensual economy without respect to the gender of those involved. And 4 states, Texas, Kansas, Oklahoma, Missouri, parts of Missouri, prohibited same-sex couples from engaging in any type of sexual activity. Now, Lawrence versus Texas started the same way that Bowers versus Hardwick did, with an arrest. Yeah. A neighbor with a grudge faked a distress call to the police, telling them that a black man was going crazy. Really? That's what we're going to do? Especially in the South? Okay. But said that a black man was going crazy in John Geddes Lawrence's apartment. Police went to the apartment, pushed open the door, and found the two men engaged in sex. Lawrence and the man he was with were charged with having deviant sex. On appeal, attorneys asked the court to dismiss the charge against Lawrence and Garner on 14th Amendment equal protection grounds, claiming that the law was unconstitutional, because it was. The Texas 14th Court of Appeals heard the case, and they said, it's unconstitutional. You're right. However, the Court of Appeals decided to review the case, and without hearing oral arguments, they reversed the three-judge panel's decision and upheld Texas's law. They said Texas law was constitutional. Now, the case finally makes its way to the Supreme Court, and in a 6-3 decision, the Supreme Court invalidated the anti-homosexual economy laws across the United States, making same-sex sexual activity legal in every state in the United States as well as United States territories. They're like, y'all, you know it's unconstitutional. Knock it off. Fun fact. There were 2 justices who disagreed with the verdict. You're going to be so surprised when I tell you who. Antonin Scalia and Clarence Thomas. They both dissented. Now, I tried to understand Scalia's reason for dissenting, and it made no sense. Because at first I thought it was one of those not embedded in the history of our nation kind of crap that he does, but that wasn't even his thing. So I'm like, it doesn't matter. But with Thomas, he's very consistent with the reason for his dissent. It's the same reason he gave for Roe versus Wade. It's the reason he gives for anything that was based on substantive rights or the right to privacy, right? His reasoning is there is no right to privacy covered under the Constitution. And I hate to break it to everybody, he's right. The right to privacy is not in the Constitution. There was a justice one day, and from what I gathered, he took a bunch of amendments, smashed them all together, took a hit of acid, squinted his eyes, and said, BAM! There's your right to privacy. And because he'd been on the bench for quite some time, everybody said, he's right. Yeah, that's what I've gathered from my reading. I hate to break it to you that way. So, now he might not have taken a hit of acid, but everything else is true. Regardless, finally, same-sex couples could get freaky in their own homes without having to worry about being arrested for doing what opposite-sex couples did. I mean, it's the 70s, and opposite-sex couples are having key parties, and they don't have to be worried about getting raided by the cops. Why should same-sex couples have to worry about it? They shouldn't. Actually, it was the 80s. I assume they were still having key parties in the 80s, weren't they?